Good afternoon, Advocate Wanless.
Good afternoon, DCJ.
How are you?
I'm very well, thank you. And yourself?
I'm fine, thank you.
Good afternoon, Commissioners.
I'm not going to keep you. I can't speak for my colleagues, though. You have appeared before this commission how many times now?
DCJ, it's in fact my fourth occasion, if one counts the October, sorry, I beg your pardon, the April 2021 interview. But hopefully this will be the third occasion that hopefully my name goes forward for consideration.
It is exactly for that reason that I'm saying I won't keep you. We know exactly who you are.
Yes.
We know that you started acting in, as far back as 2012, for example. So you're an old hand at this. And
Yes,
I just want to raise one thing with
you,
you, though. In your
Yes.
application form, you list, you list a long, well, you make a long list of, you present a long list of, it's late afternoon, you present a long list of reserve judgments dating back 6 months from the time you were preparing the document.
Yes.
Can you just explain to us how you came to, accumulate so many reserve judgments and if they have been delivered?
Yes, thank you, DCJ. I trust that my correspondence was received.
Yeah, it was.
By all, yes. So that is, I understand it's a fairly voluminous and hopefully a thorough explanation, but if I can just summarize that.
Yes.
Yes, DCJ, unfortunately, and if I may be so bold, perhaps the questionnaire I'm advised is possibly one of the things that will be looked at when the JSC looks at its criteria. But that particular subparagraph, I think it's subparagraph 9.5, which asks, do you have any reserve judgments at the time, causes difficulties because, as I've set out in the letter, when one fills it in, if it's really a matter of timing. Yeah. If you've come off 2 weeks of opposed motions and special motions and family court, and as I've set out, then obviously you're going to have a lot of reserve judgments. So in a nutshell, I've set out all the other reasons as to why. But to cut a long story short, and I know you've been at this today, DCJ, for a long time. But out of all of those judgments, which were set out at pages 8 and 9 of my letter, they have all been delivered, and the only one that has not been delivered is number 8. That's a matter of Centpred Properties, and the guideline, therefore, is in fact only the 21st of May, 2023, because I had to chase applicants' counsel to eventually give me the authorities he wanted to give me when the matter was argued.
All right.
So they're all up to date. Everything is
all but one.
No. Yes. Sorry. Well, yes, all but one. But as I say, that yes, there's,
right.
And that'll be delivered shortly.
Yeah. All right.
Yes. So
thank you.
Thank you.
Okay, JP Mlambo.
Thank you very much, DCJ. Good afternoon, Advocate Wanless.
Yes, JP. Good afternoon.
You've acted for a total of 149 weeks.
Yes, JP.
In the division. That's because you started a long time ago, and in 2015.
Yes.
And whenever we need help, we always call on you. You've helped in a number of recesses, because with the absence of judges in the division who go to other courts, even the complement that must do recess duty is not there. So that's why you've availed yourself throughout.
Yes, JP.
And just looking at this, I see you've done 25 weeks in the opposed motion court. That's seriously sizable.
Yes, JP.
Yeah. And I think you've done what?
If I may, JP, on previous interviews, that 25 weeks of opposed motions. Yes, JP.
Yes.
Sorry.
So you've been around the Gauteng division, basically. you know what the workload is like. You know what the nature of the work that comes, and you've done it.
I do.
In terms of judgments, what is your average turnaround time in terms of handing down judgments?
I think, JP, the average turnaround time until recently was always under 3 months.
Yes.
There was never there was always that. It was only, I regret, just recently when, as I set out in the letter, that I was faced with an extraordinary, judges in Gauteng have an onerous workload. I think I was faced with an extra onerous workload in one, and I'm not complaining, because it's given me an opportunity to perhaps even write better judgments on more complicated matters.
Yeah.
And more portable. But that's the average. The longest judgment is the one that is.
How long will that be?
That was 5.5 months.
Okay. So nothing over 6 months?
Never.
I see. I'm sure you've had occasion to watch some of the interviews for the week. The bar that this commission has been consistent with this week has been to ensure that whoever it recommends for appointment is someone who's technically competent, someone who's a hard worker, and someone who's conceptually up to standard. You've seen, and you may have heard that some candidates have been criticized for having a weak understanding of the law, misapplying tests. You've heard and seen all that.
Yes, Chair.
Yeah. What's the bar's comment against you?
JP, there are no adverse comments at all, as far as I can see. And in addition to that, perhaps I could just amplify it. I've certainly never had any adverse comments from colleagues when working, for example, in appeals. And I've done a lot of judgments in full court appeals where the senior judges, the
So
permanent
you
judges,
feel, I mean, you are a silk, you had a practice. And by the way, would you like to remind the commission how is it that you left KZN and came to Gauteng?
Yes, JP. It was probably an event which has potentially changed my life. I attended, in 2015, there was a conference held by the Transformation Committee of the Johannesburg Bar at Lily Leaf's Farm for acting judges. And having acted in KZN before, I elected to attend the conference, and at that conference, you, JP, were a guest speaker. And again, you made a call for the fact that, or were bemoaning the fact that the silks in Johannesburg were possibly giving you a week here and a week there, but you weren't getting much time. So, to cut a long story short, I tendered my services. Obviously, the agreement being that I would pay my own accommodation costs and my own travelling costs, which I have done in all of the weeks that in all the time that I've spent acting in Gauteng, and I've acted in Pretoria and Johannesburg, and that's how the relationship began. And again, I must say, I was welcomed with open arms. It has, if I can just finish this question just briefly, JB, I was reading the transcripts of my previous interviews, and it seems to be of some concern to some commissioners that the reason why I'm applying for a position in this, well, I'm not applying, I've been nominated for a position in this division and not KZN, but the fact is obviously that I've done 99% of
well, the
my
fact
experiences
is,
here.
after that conference,
Yes.
you had a call to me to say you would want to come and help.
Yeah.
And I didn't guarantee you that I'll appoint you all the time.
No.
Said whenever I've got available vacancies, I will.
Yeah.
And I think as your appointment will indicate, it wasn't a continuous appointment.
No.
Yeah.
No, and as I've been, I've been welcomed with open arms, and I've really enjoyed my time here with colleagues, and I think it's been a good thing. I think historically to have a cross-pollination at times, with judges from different divisions being possibly appointed in other divisions. I think it's a healthy thing. I think that one can bring different things from different, with ways of practice and possibly,
Okay.
possibly different patterns.
Now, the Gauteng division attracts, it's always in the press, in the news, with the cases it has. I mean, even this week it was in the news, last week it was in the news. Sometimes, almost daily, there's mention of a case that's being heard or a judgment handed down in Gauteng. And these are matters that are in the public domain, mostly administrative law cases. Have you had a fair share of handling these cases?
Yes, JP, I think over the time, I can't think of anything in particular.
Yes.
But there certainly have been matters which have attracted attention.
Yes.
And yes, and I've never shied away from that. You know, it's obviously very important to be independent and to be independent thinking, and to make decisions when one needs to.
And you regard yourself as eminently eminently appointable, let me use that word.
Thank you.
And
Yes, JP, I think
that's why you're sitting here talking to us today.
yes, JP, that's why I've accepted the nomination. It's
Yes.
not a personal thing. I don't have any illusions of grandeur to want to be a judge. It's a sacrifice I'm prepared to make because people want me to be, and I've been nominated, and I've accepted that nomination, and I've made certain sacrifices, which I'm quite happy to make, and to continue to do so. And I believe with my experience at the bar, which has now been 32 years, 20 years as a junior and 12 years as a silk, and that experience together with the almost 2.5 years of acting experience which I've accumulated in all these different courts, as you've said, I believe I would be, hopefully I could add some real value to your division if I was appointed to serve. JP, if I could just, before we move on, just back to the work allocation very quickly, is that you will also see that I've done, and this hasn't been raised in previous interviews, that's why I just wanted to just touch on very briefly the fact that I've also done 24 weeks in the unopposed motions. And this relates to a comment which has continuously been made in the reports by the Johannesburg Society of Advocates, and which has been confirmed by the GCB, was that my ability, and it's been commented by members of the bar, my ability to handle an unopposed motion role, lengthy unopposed motion roles, because we know how lengthy those roles can be and how difficult it is to prepare them. There can be 60, 70 matters. You've got to read all those matters, and then you've got to get through the role. And on top of that, in the words of our erstwhile DJP, what an important court it is, because, and it's a difficult court to run because it encompasses so much knowledge of so much of the rules and of various sectors of law. And it really is an important court, and I think that taking all those factors into account, and the fact that I did have, for many years as a junior counsel, have a very busy motion court practice in Durban, that I really could make a valuable contribution towards that court. And I know that, JP, you have various committees, and should I be appointed, I would certainly hold up my hand if needed for that.
My last question is, you come from a province that hasn't caught the bug fully in terms of digitization or electronic filing, and you've acted in Gauteng for this long. Are you one of those judges who are doing the physical stuff who think, I don't know? Or have you fully brought up to doing work electronically?
JP, I think I wouldn't say fully, but I think I've made great strides in that regard, and I'm certainly enjoying the case lines and court online as well.
Thank you. Thank you very much, DCJ. No further questions.
Thank you very much,
Thank you,
JP. MEC?
Thank you very much, DCJ. Good afternoon. Can I just refer you to, I see your colleagues in the GCP have made a comment about your knowledge and your capacity to do this work. And in this particular case, they say that, and that is on it's 6.5 on, I think you'll find that on, well, there's no page here, unless I'm mistaken. But you can look at the comments of the GCP about what they say. The one I'd like to quote is paragraph 6.5, which they say, whilst in practice, the candidate did not practice in the field of constitutional law, close quote. Now, for me, constitutional law permeates and is the most important pillar of the South African legal system. As you know, the Constitution is very much important to all laws, and anything inconsistent with it, it's definitely a problem. Now, can you just give me why would they say that about you? Because if that is correct, then that worries me quite seriously. That at the position you have applied for, the work that you'll be doing requires a very good knowledge and appreciation of constitutional law.
Yes. Thank you.
If you can just clarify me on that. But first, is it a fair comment? If so, just clarify me on that.
Yes, thank you, MEC. First of all, once again, it's noted that on the questionnaire there was no particular place. Well, there was when one mentions one practice, I suppose. But having said that, there was, yes, other than one matter in terms of where I was a junior counsel and I was briefed in one specific matter. There wasn't during practice. I wasn't briefed I haven't been briefed in constitutional law per se. But I think I've answered this question before in another interview. But the fact is, so I took the fact is that during my time as an acting judge, I've then had the opportunity to, and that's been 2.5 years, to in many judgments apply various constitutional principles. So I've made up through constitutional transformation, because it's obviously very important, and as you say, it underpins everything. It is the most important thing of all. So whatever I may not have had, and it's not that I didn't have any experience at all. I mean, when one argues a matter, one always refers to the Constitution, etc., etc. But I've been able to expand on that. And in one of the documents, a summary of judgments, because I've answered this question before in a previous interview, and I've said, well, that's the case, but I hadn't had an opportunity to go through. There's so many judgments I've handed down. I haven't had an opportunity to go through each one and mark where I've mentioned constitutional principles. But what I did on this occasion, when I compiled that summary of judgments, I did mark some that then correspond with the spreadsheet. So I've done that. Also in my pack, the very first judgment that I put up is a reported judgment where I've dealt with the constitutional principles in respect of unlawful arrest and detention. So I've dealt with many in many judgments with constitutional. So I think I'm, if I may use the colloquial expression, up to speed with the Constitution, and I'm a great believer in constitutional transformation, and I don't think I can answer the question any further than that.
Any questions, colleagues?
Yes, may I please ask Deputy Chief Justice? Good afternoon, Mr. Wanless.
Good afternoon, Commissioner.
Could I ask, apropos the points that are being raised by the MEC about your grasp of the Constitution,
Yeah.
to just test in relation to the common law of contract, and specifically to ask whether, in terms of our law as it stands, it is permissible for a court to refuse to enforce a contractual term on the grounds that, from a constitutional perspective, the enforcement would be unfair, would be unreasonable, or would be unjust.
Yes.
And what are the leading cases, even if it's one or two?
Commissioner, I'm going to be able to answer the matter in principle, on principles, but my memory fails me when it comes to the name of the matter. But that would be
No problem.
That would be the debate between, essentially put another way, between Pacta Servanda Sunt and the principle of Ubuntu. Is another way that it has been put by certain writers. Would that?
No, I'm not talking about Ubuntu. I'm talking about three specific terms:
Three specific terms.
good faith,
Good faith. Yeah.
unfairness, and reasonableness.
Well, putting that aside, the way I understand the law at present is that because of the principle of legality and certainty, that, and the constitutional right to freedom of contract, that our courts have not gone that far at this stage to entrench those principles in any decisions that I'm aware of.
Yes, and the judgment of Botha versus Botha of the Constitutional Court, didn't the court invalidate a contract there on that basis?
Well, I'm not. You may well be right, Commissioner. Regrettably, obviously, we can't know everything, and we learn as we go along, and that's the exciting thing about the law. And it hasn't crossed my desk at the moment, but hopefully it will. And if it does, then I'll certainly remember the matter.
Well, the judgment was subsequently distinguished by the Constitutional Court, which came back to the principle that pacta servanda sunt, or pacta sunt servanda,
Pacta sunt
remains applicable.
Yes, yes. So we still. So was I right then, Commissioner?
So in your original answer, which you should have stuck to it.
Yes, yes. I was just being honest, Commissioner, to say I hadn't read Botha versus Botha. So.
Any?
Good afternoon, Mr. Wanless.
Yes.
Just two questions. You've acted then, I mean, you're residing in Durban.
Yes.
That's is what you've put down as your address.
Yes.
But you only acted in KwaZulu-Natal for under a month.
Correct.
In 2012, and then you never acted there again. Do you want to
Yes.
just comment on that? It's a bit odd that you don't want to try and get broader experience and take an acting position from where you're actually living.
That seems to be, Commissioner, that also seems to be a question that is, for some reason or not, perturbed the Commission in my previous interviews. I can't explain it. I can explain it in this way, is that, and I think I have in previous interviews. The fact is that first of all, to get an acting appointment, to render your services and serve one, to assist in the administration of justice in KZN, is far more difficult than it is in Gauteng because of the size of the court. They just don't employ or ask for the assistance of that many acting judges. So that was the first point. The second point being that when one, having now built up the relationship that I have with Gauteng, I was now obviously out of mind, out of sight, or out of sight, out of mind. So once everybody knew I was spending this time in Gauteng where I was being asked to act. So it became really sort of immaterial. And again, because of the relationship and because of the way I was welcomed here in this division, and should this commission decide that I am suitable for appointment, then my wife and I have obviously discussed the situation, and then there'll be a permanent move to Gauteng.
Okay, thanks. Sorry, I wasn't present when you were interviewed before.
No, I understand.
My second question is, you would have been conscripted for 2 years. Is that a yes? Sorry, I can't see.
Yes, sorry, yes,
okay.
sorry, yes.
Why don't you put that on your CV? It was employment. It was conscription. It's just that we had a earlier candidate today who did put it on their CV. Wasn't an issue, nobody raised it. But I just was surprised, the question on the JSC questionnaire is please furnish chronological particulars of employment since leaving school or university. Yes. And it's 2 years. Why didn't you disclose it?
Commissioner, it wasn't a deliberate thing by any means, and thank you for raising it. It hasn't been raised before in any previous. I think certainly it's not employment. So it didn't. That's really the only reason I can think why I didn't put it down. It's certainly
you saying it
wasn't.
wasn't employment?
No, no.
You were remunerated.
Well,
Probably
hard-
wasn't much, but
No, no, it certainly wasn't much. No.
but you were remunerated, so that's employment.
Well, I won't split hairs, Commissioner, but, well, possibly it was just something I didn't, I just omitted it. There was, as I say, there wasn't any intentional, reason for that.
Okay, thank you.
I think you've declared it before, though.
Have I?
I seem
must-
to remember that, yeah.
Yes, thank you.
Any more questions for the candidates? Commissioner Malema?
Just a brief understanding of customary law.
Yes. A brief understanding, Commissioner. Yes, Commissioner, obviously it plays an important part of the development of our law, and in terms of section, I think it's subsection 211, subsection 3 of the Constitution, it must be applied. Customary law must be applied unless there's other legislation that conflicts with it, or it's in conflict with the Constitution. I've heard lots of. I know the other commissioner has asked various other candidates questions on that. I think that the test. I don't know whether I want me to answer the other commissioner's question, but
Carry on, tell us the test.
the test, yes. The test is, and I never heard any of the other candidates answer it, but in terms of those, in terms of the matters that you mentioned, Commissioner, I think the way I understand the test is that the court must obviously look to evidence of ordinary people. That would be the first thing, or evidence of traditional leaders, and evidence of experts, but certainly to be wary of old authorities, because that obviously takes one back, and clearly customary law in itself is something that is always developing on its own, but needs to be encouraged in terms of decisions wherever possible. So wherever the court can apply customary law, that should be done.
55%.
Just done. Thank you, Commissioner.
Commissioner Nyambi?
Thanks, DCJ. Afternoon, Advocate Wanless.
Good afternoon, Commissioner.
In your view, what do you think would be the role of traditional courts in the administration of justice in South Africa?
I must confess to answer that question, Commissioner. First of all, I don't have an in-depth knowledge or understanding of the structures necessarily of those courts, but certainly if the traditional courts are obviously passing down orders or judgments in terms of customary law, then I think that's very important, and I think that is law that should be taken into account by the High Court, by the SCA, and by the Constitutional Court.
Thanks. Thank you, DCJ.
Any questions from the virtual platform? Prof? Commissioner Singh?
None for me, DCJ.
Commissioner Bernard?
None from me, DCJ.
All right. Well, we have reached the end of the road this time, Advocate Wanless.
Thank you.
Thank you for making yourself available once more. I hope things will go well for you this time around.
Thank you, DCJ. May I know it's been a long day, but may I simply make a very brief closing statement?
Yes.
Thank you. I know that, and I would just like to first of all acknowledge what a privilege it's been to once again to appear before this commission and to be shortlisted along with other candidates. But I think I touched on this earlier, but I just wanted to, for the sake of the commission and also for members of the public who may be watching this, that I know that, I think sometimes there's an impression that candidates or some candidates may be doing this, maybe applying for some personal interests. And I just simply wish to say that that's not, certainly not in my case. That's when I mentioned earlier, I don't have any illusions of grandeur in seeking the position. I'm 60 years of age. I can offer the Gauteng division another 15 years of service. I think I've proven that service. I think I'd be a valuable member of the judiciary. And simply to act, just really the reason that I'm here is because I've been nominated for the position and asked to put myself forward. And I've accepted those nominations because I believe I am suitably qualified. And I believe my commitment and the sacrifice that I have made by the traveling expenses, the accommodation expenses, et cetera, speak for that. Again, there's been the experience, I've already touched on that. So I just wanted to say thank you. I'm ready to swap my Amazulu shirt for I don't know if it's a Kaiser Chief or Orlando Pirates, I'm not sure, anytime if needed to be. And certainly my Sharks jersey will get tossed out of the, I'll have to buy a Lions one, or maybe a Blue Bulls, I'm not sure. But thank you very much for your time, and I'd like to just simply lastly commend the commissioners and this commission for your invaluable role that you play. I mean, growing our democracy and most importantly, MEC, our constitution. So thank you very much. Yebo. So, ngibonga kakhulu, Salagashli.